Thank you, Neil. Can you hear me now? So sorry. Guys, am I audible to everyone? Hi, am I audible to everyone? Perfect. Thank you, Pitambar. So, in this video, we are going to welcome to the legal world of Unacademy. In this video, we are going to talk about a very sensitive issue. Can hospital deny assistance to a road accident victim? And we are going to look into the case of Pandit Parmanand Katara versus Union of India. It was a PIL filed by Mr. Parmanand Katara. He is an advocate, and so the prime reason was कि अगर कोई road accident होता है उसके बाद आप hospital में जाते you have to go through so many legal formalities that what is the we have to look into this that the medical practitioners have the right to पहले legal formalities में बहुत time आपका खराब हो जाता है so इस concern को लेते हुए ये PIL फाइल हुई थी मिस्टर परमानंद कटारा के द्वारा so first of all let me introduce myself my name is Tanvi Singh I am a I have pursued my LLB from Symbiosis Law School, Pune. Earlier, I have worked with various organizations. Okay, I'm not able to understand. Okay, perfect. Now the video is fine. All right, sorry guys. Let me open the chat box. Huh. So earlier, I have worked at various organizations, law firms, legal publishing industry, and I have been mentoring aspirants for law exams since last 5 years. Currently, I am your Unacademy CLAT educator. So let's start our session. First of all, let's understand the need of such a right. So every individual needs to be cognizant of his or her legal rights. One such substantial right that the citizens must be aware of is the right of accident victims to get immediate medical assistance. This right has been enshrined in the judgment of Pandit Parmanand Katara versus Union of India, where there was a need for bringing immediate medical aid to accident victims has been highlighted. So, as rightly observed in this judgment, there have been ambiguities along with a sense of fear among people to help the victims of road accidents. Now, this is because it has been assumed. ये assume किया जाता है कि एक person बहुत बुरी तरह इंजर हो चुका है रोड एक्सीडेंट पे तो उसकी हेल्प करनी चाहिए उसको ट्रीट करना चाहिए आफ्टर द कंप्लीशन ऑफ लीगल फॉर्मेलिटी दिस इज हाउ इट गोज फर्स्ट ऑफ ऑल यू विल गेट अ फॉर्म यू हैव टू फिल दैट right not only this even at times the hospitals or medical institutions they refuse to entertain such victims and provide them with treatment therefore thus seeking clarifications on this aspect a public interest litigation was filed by a human rights activist in the Supreme Court. So, following which it was considered that the right to life is judgment में ये held किया गया that right to life is of paramount importance and in cases of emergency, such right would override the legal as well as medical formalities, thereby making it obligatory for doctors, hospitals, medical institutions प्राइवेट हो या पब्लिक हो to extend their services to protect life and provide such road accident victims with immediate medical support. So I hope you guys are with me and we are going to also know about the Cyrus Mistry case in this video. So most of us must be aware of the oath taken by the doctors. सबको पता होगा क्या ओथ लिया गया है, डॉक्टर्स ने क्या लिया है, that they have a duty upon them to preserve the lives of the injured, mitigate their sufferings, uphold the primacy of life, and perform other professional duties. Thus, following the moral ethical principles of medicine, the doctors must practice their profession without distinguishing on the medico-legal cases. So, in the general parlance, what happens is that even doctors are scared कि अगर हम इस केस को इंस्पेक्ट कर लेंगे, we are going to perform a surgery on it, no forms have been signed, so probably they are also liable for something. So they must understand the oath that they have taken, and doctor must practice their profession without distinguishing on the basis of medical legal cases. So medical legal cases include victims of road accidents, having some serious injury or ailment that requires the involvement of law enforcement agencies. You have to fill a particular legal form, and such cases are believed to be dealt with only by certain hospitals. कुछ ही hospitals ऐसे cases लेंगे. Medical institutions that are authorized to treat victims of road accidents. कई hospitals में जाते हैं लोग and they are denied the medical assistance. However, with the help of this ruling, ये जो आपका PIL में decision आया है, which we are going to study, it has been decided that neither a road accident victim having an emergency case shall be denied with immediate medical assistance. कोई भी रोड एक्सीडेंट का विक्टिम आता है इमरजेंसी केस में, उसको immediate medical assistance देना ही देना है. It cannot be denied. Nor shall he be redirected to other medical institution or hospitals. उसको किसी और हॉस्पिटल में भेजा नहीं जाएगा. That particularly deals with medical legal cases. जहां पे भी जैसे भी सिचुएशन में इमरजेंसी केस में आया है कोई आपके पास, the doctors have the duty to provide him or her with immediate medical assistance. So what happened in the case of Parmanand Katara versus Union of India? Pandit Parmanand Katara कौन है ये? So he is presently a senior advocate. He is also a human rights activist. Approached the Honorable Supreme Court of India by filing a public interest litigation. Now, the PIL was filed on the basis of a newspaper report, Law Helps the Injured to Die. Law helps the injured to die. So, this newspaper report was published in Hindustan Times and it discussed the death of a scooterist. एक scooter चला रहा था, he was knocked down by a speeding car. And this person was refused treatment by the doctor on the ground that the particular hospital was not authorized to handle medical legal cases. So on this, a newspaper report was published, Law Helps the Injured to Die. तो इसके बेसिस पे मिस्टर पंडित परमानंद कटारा ने पब्लिक इंटरेस्ट लिटिगेशन फाइल किया था. He approached the Honorable Supreme Court of India. Now, the person who happened to witness the accident, ये जो एक्सीडेंट हुआ था उसमें एक पर्सन था जिसने विटनेस किया, उसने विक्टिम की मदद करी. He assisted the victim in approaching the nearest hospital also and was then redirected to visit another hospital that was at a distance of 20 kilometers, which particularly dealt with the medical legal cases. So he had to face this. However, what happened here? The victim succumbed to his injuries and died on the way. 20 kilometer ke distance mein. Fortunately, this news article was enough for Pandit Parmanand Katara to take action and seek clarification on this law point from the Honorable Supreme Court, the apex court of the country. Hello, Krish, how are you? Oh, Neil, it actually happened. Yes. But now you have the knowledge of this judgment. You can simply point this out anywhere. ठीक है, आज बताना family में about this. So, what happened? Now, Pandit Parmanand Katara, he filed the PIL. उन्होंने जो reliefs मांगी, he sought for certain directions to be issued to the Union of India. कि कुछ डायरेक्शंस सुप्रीम कोर्ट यूनियन ऑफ इंडिया को इशू करे. First of all, it was that it must be compulsory that any injured victim that is brought for treatment must be immediately given medical assistance for the purpose of preserving his life. Immediate treatment मिलना चाहिए. All right, guys. Oh, yes, I can see the chat box. Hello, Alisa. So we are doing this judgment of Pandit Parmanand Katara. It's a very interesting judgment, a very interesting point of law that we are discussing today, guys. So पहला इनका ये था कि आपको सुप्रीम कोर्ट डायरेक्ट करे यूनियन ऑफ इंडिया को कि कंपलसरी ऐसे लॉ बनाए दैट कोई भी इंजर्ड विक्टिम किसी भी हॉस्पिटल में जाता है उसको इमीडिएटली मेडिकल असिस्टेंस देनी है फॉर द पर्पस ऑफ प्रिजर्विंग हिज लाइफ. उसको डिले करना, रेफरिंग इट टू अनदर हॉस्पिटल, दैट टेक्स टाइम और उससे there is a chance that the person could succumb to his injuries and die. Second direction which he sought from Supreme Court to the Union of India was that only after the victim is treated, जब victim treat हो जाएगा, the procedural criminal law should be followed. आप जो फॉर्म फिल कराते हो वो आपकी victim के ट्रीटमेंट के बाद भी हो सकता है. तो ये मैंडेटरी ऐसा कुछ लॉ यूनियन ऑफ इंडिया लेकर आए दैट आफ्टर द विक्टिम इज ट्रीटेड द प्रोसीजरल क्रिमिनल लॉ शुड बी फॉलोड. दिस शैल हेल्प इन अवॉइडिंग एनी सॉर्ट ऑफ नेग्लिजेंट डेथ. थर्ड डायरेक्शन दैट ही आस्क्ड फॉर वाज इन केस व्हेन सच डायरेक्शन इज नॉट फॉलोड. अब अगर फॉलो नहीं होगा ये डायरेक्शन, अगर किसी कंसर्न हॉस्पिटल, डॉक्टर, मेडिकल इंस्टीट्यूशन, प्राइवेट और पब्लिक हैज डिनाइड इमीडिएट medical care to the victim of road accidents. In such case, strict action shall be taken for the negligent act along with appropriate compensation. Right? Now, let's look at the response of the opposite party. अब opposite party क्या कह रही थी? So the Honorable Supreme Court impleaded, ठीक है, उन्होंने एक implead किया Secretary, Ministry of Health and Family Welfare of the Union of India, Medical Council of India, and Indian Medical Association as respondents. Now, here reference was made by the Medical Council of India. अब Medical Council of India ने दो clauses बताए. Code of Medical Ethics जो है उस पे दो clauses हैं 10 and 13, जिसके बारे में Medical Council of India ने बताया that dealt with obligations to the sick and patients not to be neglected. Let's look at these clauses. So clause 10 of the Code of Medical Ethics says that no physician is mandated to treat patients except those in emergencies. And he must not overlook the lives of people dependent on his skill and attention. तो अगर इमरजेंसी में कोई केस आता है तो फिजिशियन हैज टू ट्रीट दैट. ये आपका क्लॉज 10 कहता है कोड ऑफ मेडिकल एथिक्स. एंड द गाइडिंग प्रिंसिपल बिहाइंड क्लॉज 13 इज दैट ऑल्दो द फिजिशियन इज फ्री टू चूज whom he shall serve. फिजिशियन के पास ये फ्रीडम है कि वो चूज करेगा कि वो किसको ट्रीट करना चाहता है, बट ही मस्ट रिस्पॉन्ड टू इमरजेंसी केसेस and specially not neglect those patients who are being treated by them. So Medical Council of India ने ये भी mention किया that no provision of law prevents the medical practitioner from attending to the injured. The Medical Council of India clearly stated that these are the we have such laws कि immediate medical care आपको देना है. ठीक है, ये response था opposite party का. Now, Indian Medical Association also highlighted the reason behind the rising death rate. The same was due to the lack of immediate medical assistance provided to such victims. Although it is quite important to secure the evidence and keep it intact, such formalities are not above the valuable life of a person. Hence, it can be viewed that there was no objection raised from the government of India. Understood? So before learning the judgment, let me see the chat box. Hello, Alisa. Hello, Sumit. I hope you guys are doing good. Yes, Krish. Okay. Oh, that's sad, Krish. उनका ब्लड साफ के बस 115 किलोमीटर्स। यू शुड तुरंत गूगल करना चाहिए ऐसे सर्कमस्टांसेस में कि व्हाट इज द लॉ विथ रिस्पेक्ट टू दिस। सो पुलिस के अगेंस्ट यू कैन गो फॉर अ रिट पेटिशन। आप मैंडेमिस के लिए रिक्वेस्ट कर सकते हो, रिट ऑफ मैंडेमिस, सो दैट द सुप्रीम कोर्ट कैन गिव डायरेक्शंस टू द पुलिस टू परफॉर्म देयर ड्यूटी। ओके, नाउ लेट्स लुक एट द जजमेंट। क्या डिसीजन मिला इन दिस पीआईएल? Pandit Parmanand Katara versus Union of India. So while deciding the said issue, Honorable Justice Ranganath Mishra and Honorable Justice G.L. Oza disposed of this writ petition filed in the nature of PIL by making following observations. Firstly, the judges held that Article 21 of the Indian Constitution casts a duty upon the state for upholding the right of the preservation of valuable human life. Preservation of valuable human life is of utmost significance. आपको किसी की जान बचानी है. This is so because when a life is lost, the status quo ante shall not be restored. आप एक बार लाइफ लूज हो गई, कोई किसी की डेथ हो जाती है, तो यू कैन नॉट ब्रिंग देम बैक टू लाइफ, राइट? सो इमीडिएट केयर इज सो इम्पॉर्टेंट. Supreme Court also said it is not for the healthcare workers to decide. Healthcare workers के हाथ में नहीं है that they have to decide and treat an individual based on his status, meaning preserving his life on the basis that whether he is innocent or guilty and punishable under law. That is not the healthcare workers do not have any say in this. The work of healthcare workers is only limited to provide immediate medical assistance, preserve their lives without considering the status of the injured. Clear? Also, Supreme Court ने और भी चीजें बोली that every legal medical practitioner working at a government hospital or a private hospital or any other medical institution must provide the best treatment to the patients and extend his services with due expertise. Right to life is of paramount importance, and no statute or provision of law can intervene and obstruct the treatment of victims of road accidents. Steps were taken to aware people of this ruling and the rights available to them per se. कि लोगों को इस रूलिंग के बारे में पता चले. Now, steps must not be taken by healthcare workers, but even the police officials and citizens witnessing such road accident must take immediate steps to preserve the life of the injured. This is what the court held. Also, members जो होते bar and bench के आपके members must keep in mind that the crucial time of medical professionals must not be wasted. Such medical practitioners and other medical professionals must not be unnecessarily investigated, prosecuted and harassed. जब तक आपके पास बहुत ही ऐसा कुछ evidence नहीं है, आपको नहीं disturb करना है. The courts shall endeavor to not summon medical practitioners to give evidence unless the evidence is significant. However, if they are summoned in a case, efforts must be taken to not waste their crucial time. Right? So, court further held that Article 21 of the Constitution of India provides the right to health, forms an indispensable part of life to life. Right to health is also an indispensable part of right to life. So Pandit Parmanand Katara versus Union of India is a landmark judgment that upholds the preservation of life and considers the right of life to be of utmost importance. The petitioner filed a public interest litigation observing that there are no laws governing the provision of immediate medical assistance to the victims of road accident. Pandit Parmanand Katara ने Supreme Court approach किया था through this public interest litigation because he observed कि यहाँ पे कोई laws नहीं है. So, with respect to the immediate medical assistance, following which the Honorable Supreme Court directed all the medical institutions to first treat the patients and thereafter comply with the formalities laid down under criminal law. तो ऑनरेबल सुप्रीम कोर्ट ने सारे मेडिकल इंस्टीट्यूशंस को डायरेक्ट किया कि सबसे पहले ऐसी सिचुएशन में, इमरजेंसी सिचुएशन में कोई पेशेंट आता है, यू हैव टू फर्स्ट ट्रीट द पेशेंट एंड आफ्टर दैट you have to proceed with the criminal procedural formalities that has to be done. So the contribution of the petitioner, namely Pandit Parmanand Katara, is quite laudable. His efforts helped him get nominated for an award considered as an alternative to Nobel Prize. This landmark judgment was passed in the era when PIL was being used as a tool for bringing social change. Now let's come to Cyrus Mistry's death. ये तो सबको पता होगा, सबने वो सीसीटीवी फुटेज देखा है, isn't it? Everybody has seen the footage. So the death of former chairman of Tata Sons Cyrus Mistry अरे nobody knows about it. तो अभी ये बहुत ही recent है, आपका पिछले 3 महीने में ये accident हुआ है. Very dangerous. Do Google it. The CCTV footage is available on the internet. Okay. So death of former chairman of Tata Sons, Cyrus Mistry, in a road accident near Palghar in Maharashtra has triggered a debate on road safety. The experts ने ये देखा है, have pressed for the need to keep a check on speeding vehicles and making the use of seat belts for rear passengers mandatory. Social media में this became very viral that you should use the rear seat belts also. So Mr. Mistry was not wearing his seat belt at the time when the Mercedes-Benz GLC in which he was traveling hit a divider of a bridge over River Surya. A primary probe has revealed. He was sitting on the rear seat. He was sitting at the back only. वहां पे उन्होंने सीट बेल्ट नहीं लगाया. अब आप बोलोगे मैम बैक पे तो मैं भी नहीं लगाता हूं. So now the road safety laws have been developed after this accident, and we are going to learn about it today. So he was killed on the spot. His death has triggered yet another debate on seatbelt laws in India. This was very much viral on social media that पीछे भी जो बैठ रहा है, they have to mandatorily wear a seatbelt, else they will be fined, if you must have noticed. Now, what happened here? Police in Maharashtra's Palghar district have obtained the CCTV footage of the ill-fated Mercedes car in which Cyrus Mistry, former chairman of Tata Sons, was traveling to Mumbai shortly before it crashed, killing him and his friend. The footage shows that the car passing through the Dapchari checkpost in Palghar district at 2:21 p.m. on Sunday, the car hit a road divider on a bridge. एक रोड डिवाइडर पे जाके कार लड़ती है एक ब्रिज पे over the Surya River on the Mumbai-Ahmedabad highway at around 3 p.m., killing Mistry 54 and his friend Jahangir Pandole on the spot. फ्रंट सीट की भी नहीं लगाते लोग. It's so that's very dangerous, guys. Please make sure, even if you are sitting at the back seat, use seat belts. Because you know what happens? अगर आपने पीछे सीट बेल्ट नहीं पहना है और एक क्रैश होता है, तो what happens is the person who is sitting at the back, he is very dangerous to others also, क्योंकि वो पीछे से आगे की तरफ वो पुश होगा, right? And his body could hit, वो इस velocity से पुश होगा आगे की तरफ कि his body could hit Anybody, and the person could be heavily injured or probably die. So, if you are not wearing a seat belt, it's not only dangerous to you, but it's dangerous to everyone who's sitting in car with you. Check out the videos on YouTube कि पीछे सीट बेल्ट नहीं लगाया है तो फिर कैसे एक्सीडेंट्स हुए हैं. Hello Piyush Sahu, how are you? Now, the three major takeaways from Sunday's accident in which Cyrus Mistry was killed. It was a Sunday, guys. Chief Scientist, Central Road Research Institute, New Delhi, S. Velmurugan told PTI that there are three major takeaways from Sunday's accident. First of all, roads, especially highways, must have consistent designs. Highways must have proper signages, awareness about wearing seat belts in the rear, and enforcement of the law. People must be made aware of the dangerousness of if you are not wearing the seat belt at the back also, at the rear end. Now, let's understand the recent developments in road safety. तो ये एक्सीडेंट आपका आई थिंक फर्स्ट वीक ऑफ सितंबर में हुआ था. नहीं, this is on September 13, 2014. एक ड्राफ्ट बिल आपका titled Road Transport and Safety Bill 2014 was placed on the official website of Ministry of Road Transport and Highways, Government of India, to seek feedback from the people in order to replace existing road safety legislative framework with the proposed new act. Now, the bill contains 340 sections, 15 chapters, and 4 schedules. The objective of the bill is to reduce road traffic accident deaths, improve GDP, and to create jobs in order to enable the mission of Make in India. A bill ने क्या propose किया? Setting up of an independent institution for vehicle regulation and road safety, and an innovative funding mechanism to implement safety programs. A transparent single window driver licensing system, unified vehicle registration system, simplified permits, adoption of innovative and new technologies, development of integrated transport system, regulation of public transportation in eco-friendly manner. Special emphasis on the safety of school children, disabled person, and security of women. Creation of motor accident fund for immediate relief to accident victims. Cashless treatment for victims of accidents during golden hour. Speed limits to be posted on all roads. Prohibition of handheld communication devices while driving. Framework to prevent overloading of vehicles. Standards and guidelines for road infrastructure development and construction. Private partnership in vehicle fitness testing. Roadworthiness tests for all vehicles, impairment test, breath test, clinical test in case of suspicion about fitness of the driver, requirement of vehicle type approval certification, certification of conformity, unique identification mark, and the display of registration mark for all the motor vehicles to be used in public place. Safety performance test, competency test to ensure road safety. Bill also proposes increased penalties for the contravention of provision of the Act and provides for electronic detection and centralized offences information to identify repeat offenders. Also, ये सारे offences और penalty भी हैं उसमें. Driving a motor vehicle without valid license, तो ये penalty है. Causing unauthorized person to drive. Manufacturing of faulty vehicles, using vehicle without registration permit, driving without the consent of owner, driving against the authorized flow of traffic, not giving away to emergency vehicles, dangerous driving with children on board, driving under the influence of alcohol, driving vehicle exceeding permissible weights, driving uninsured vehicle, violation of traffic signal, use of handheld communication device while driving, not wearing seatbelt or protective gear while driving, causing obstruction to free flow of traffic, racing at trials of speed, disobey of traffic signals at railway crossing, causing children to sit without seat belts. And also one more thing which I would like to add, the recent development. This is the most recent development that has been done. So notification has been issued for constitution of National Road Safety. Ministry of Transport and Road Transport and Highways have notified constitution of the National Road Safety Board along with the rules thereof on 3rd September 2021. The rules specify provisions regarding its composition, eligibility of chairman. The head office of the board shall be in the National Capital Region. The board shall be responsible for promoting road safety, innovation, and adoption of new technology for regulating traffic and motor vehicles. For this purposes, inter alia, the board shall formulate specific standards for road safety, traffic management, and road construction for hilly regions, guidelines for capacity building, development of skills for traffic police, hospital authorities, highway authorities, education and research organizations, and other organizations. Provide technical advice and assistance to the central government, state government, and local authorities on road safety and traffic management. Promote good Samaritans, good practices in road safety, traffic management, new vehicle technology in the field of vehicular engineering, coordination with international organization, consistency between international technical standards and domestic technical standards, conduct research to improve road safety, traffic management, and crash investigation. Other than this, one more draft has been filed, which was due for approval, in which seat belts ke liye, there are going to be stringent laws on the seat belts, that you have to wear seat belts at the rear of the car as well. So guys, it's very dangerous to sit in a car without a seat belt. It's my kind request for everyone that whoever is around you, make them aware of the dangerous implications of not wearing a seat belt. Your life is precious. In fact, the person who is sitting next to you, if you are not wearing a seat belt, then his life is also in danger. Check out the videos on YouTube. If the rare seat पे अगर किसी ने seat belt नहीं लगाया तो कैसे crash में होता है. So thank you so much. That's it for the day. Yes, yes, I drive car. We will understand, but what about the people who are not wearing the helmets and seat belts? हाँ, so उनके लिए penalties होंगी. अभी laws और stringent होंगे. Driving without seat belts and safety. Definitely. That's true, Pidambar. All right then, thank you guys. We have 2 more special classes today. So 9:20 p.m. we are studying about, you'll get the updates on the Telegram channel. We are going to cover the schedules of the Indian Constitution at 9:20 p.m. All right, see you there.